Epstein survivors say DOJ violated privacy in latest document release. The U.S. Department of Justice's massive document dump related to convicted sex offender Jeffrey Epstein has ignited fierce criticism from survivors, lawmakers, and advocacy groups, not just for what was disclosed, but for how it was done. Survivors of Epstein's sexual abuse say the DOJ failed to protect their privacy in its latest release of files, and in some cases exposed their identities, while simultaneously withholding or redacting key details about alleged abusers. What was released? Under the Epstein Files Transparency Act, a bipartisan law passed in November 2025, the DOJ has been forced to publish its files related to Epstein's federal investigations. Late January 2026 saw a major release of more than 3 million pages of records, including videos, images, emails, and investigative material. Deputy Attorney General Todd Blanche said the department has complied with the statute and that this phase of the release represents a substantial disclosure of materials in its possession. However, critics note that only about half of the identified files have been published so far. Privacy concerns and survivor outrage. Many survivors and legal advocates argue the DOJ's release was mishandled. Victim identities and sensitive details were reportedly exposed in some records, even as other substantial sections remain redacted or withheld. Survivors say the department did not take adequate steps to protect their personal information, causing trauma and risking further harm. Some high-profile references in the files have drawn intense public scrutiny, while other alleged abusers' names remain redacted or obscured. Allegations of incomplete and selective disclosure. Beyond privacy issues, lawmakers and watchdogs say the DOJ has failed to fully comply with the transparency law. Congressional Democrats and survivors accuse the department of withholding key files that could shed light on Epstein's network and potential co-conspirators. Critics argue that more than 3 million pages released represent only a portion of the millions of pages identified as relevant to the statute. Some lawmakers have called for further judicial oversight or a special master to ensure compliance and protect survivors' rights. DOJ's response and legal justifications. The Justice Department has defended its approach, stating that certain material, especially that involving child abuse imagery, medical records, and other highly sensitive content, must be withheld or redacted to protect privacy and ongoing investigations. Redactions and selective withholding are legally justified and not designed to protect specific individuals. Deputy AG Blanche also pointed to the extraordinary volume of material, noting that a full, rapid release with careful redactions is a massive undertaking. Ongoing political and public fallout. The revelation of certain names, limited transparency, and apparent privacy issues has prolonged the debate over how the government handles high-profile disclosures tied to criminal investigations. Survivors and advocacy groups are demanding unredacted access for themselves and lawmakers. Political pressure continues from both parties, with calls for more comprehensive releases. Public interest in the Epstein files remains intense, with continued scrutiny of the DOJ's process and motives.